Morning. Welcome to the Los Angeles World Affairs Council and Town Hall. I'm Kim McClary, President and CEO. It's my great pleasure to introduce today's program, The Future of Our Nation, Should Trump Be Indicted? In keeping with our nonpartisan mission, we are offering a pros and cons perspective today. For those of you who would like to submit questions, there's a Q&A box at the bottom of your screen that you can enter your questions. Rachel Kennardine, our community manager, will be managing your questions during the Q&A segment that will start in about 35 minutes. It's now my great pleasure to bring on our moderator, Doyle McManus, who is a Washington columnist at the Los Angeles Times, Ambassador Norman Eisen, who is a senior fellow in governance studies from the Brookings Institution, and Paul Rosenzweig, who is the founder of the Red Branch Consulting PLLC. Gentlemen, we are all so looking forward to today's program. Doyle, let me turn this over to you. Thank you.
Good morning, and thank you for coming to all of my friends and readers in Los Angeles. I miss California dearly. So does Norm, I think, who is a native Californian. Paul Rosenzweig, I do not believe is a Californian, but we would welcome him to our shores. President Trump has been out of office for a year and a half, as you know, but his legal entanglements live on, and I think it's a fair and nonpartisan judgment to make that, if anything, they are more complicated now than the day he rather reluctantly left office. And we know in the largest part of the picture of two major federal investigations, one of which stemming from the events of January 6th, we are told is the largest investigation in the history of the Justice Department and the FBI, but as well joined by the investigation of the presence of government documents at Mar-a-Lago. And those and other investigations raise important questions, not just the straightforward spectators or news analysts or political junkies question of whether former President Trump is likely to be indicted, but the important questions of what the consequences for the country and the justice system might be. And for one of the many bottom lines, whether the unprecedented step of indicting a former president, what elements should an attorney general bring to bear on that decision? So we'll start with a quick take on all of those questions by our two distinguished panelists, and then I will jump in and mix it up. But I have no doubt that by the half-hour mark, there will be lots of good and piercing questions from our audience. So let me start with Ambassador Eisen. Norm, do you think the evidence is there that would justify an indictment of Mr. Trump, and what would the consequences be?
Doyle, let me start by thanking you and the Los Angeles World Affairs Council for having me today, by saying how pleased I am to be in conversation with Doyle. I'm, as he referenced, a Los Angeles native. I'll be back for at least one game of the playoffs, and we hope and feel confident after last night, the championship series, perhaps the World Series. And what a pleasure to be here with my friend Paul Rosenzweig, who really is one of the most distinguished analysts and thinkers about these problems. I do think the evidence is there for an indictment of the president. my own, and I start with the assessment of another Californian Doyle, Judge David Carter, one of our distinguished federal judges, who looked at the attempted coup and found that there was likely criminal conduct in two regards. First, that the president and his alleged co-conspirators were involved in a conspiracy to defraud the United States by fobbing false electoral slates and other fraudulent efforts upon the country to try to, the fraud being that then President Trump lost the election. He was trying to fraudulently hang on to the White House. The Judge Carter's second assessment was that there was also, that was one part of what he called an attempted coup in search of a legal theory. And the second part was obstruction of an official proceeding in Congress, because when these other frauds didn't work, President Trump essentially unleashed the mob on Congress, knowing that he was obstructing its operations. There are other possible theories there, but on those two theories, I think we have seen the January 6th committee tomorrow will get its 9th and final iteration, more proof, according to the media this morning, more proof that Donald Trump knew of the risk of violence on January 6th. I think the January 6th committee has brought us to a point where a prosecution is appropriate under the federal standards of prosecution as set forth in the U.S. Attorney's Manual. I believe that there's proof sufficient to persuade a jury beyond a reasonable doubt that these crimes occurred. And turning to the second part of your question, whether it should be done, and I'm almost done, I'll pass back. I believe that, there are profound concerns. Paul has raised some in his writing about having an attorney general who is the appointee, confirmed with the advice and consent of the Senate, but still the appointee of the former president's political opponent, now going after him for his misconduct. And we'll get into this, but my view is that given this new, I wasn't here at every point of the past 2 years, but given the new proof that the committee has proved in, I've cataloged it all in a running essay series on the Just Security website after every hearing, that to have this powerful evidence that the law has been violated and for the AG not to bring charges would be a greater affront than the risks of the appearance of political prosecution, would be a deeper insult to the core idea of the founding of our country as expressed in the Constitution and other founding documents, that no person is above the law. That's why America was founded. We were ruled by a king who claimed that he was the law. And we replace that with a constitutional and a rule of law system. The law is our ruler, no one is above it. And Merrick Garland would be giving affront to that principle if he were not to charge based on this powerful evidence. We'll talk about other complexities like the pending Georgia prosecution as we go. That's my view of the evidence and of the Attorney General's looming decision.
Thank you, Norm. That was characteristically vigorous and concise, uncharacteristically concise, actually, I should say.
Indeed.
Paul,
I'm surprised at myself.
Paul, over to you, and let's focus, as Norm did, on the January 6th issues. Is the evidence there? Is it sufficient to persuade a jury? An important consideration. And what other considerations may or should the Attorney General be keeping in mind?
Well, thanks for that, Doyle, and thanks to LA Watch for inviting me. I should note that I did live in San Diego for a few years, and so in the unending debate over the Padres versus the Dodgers, I'm afraid I have to take the Padres side right now. But I hope that you'll forgive me and nonetheless let me still participate in the call today. Yeah, I think that the best way to answer your question is really to say that there is no good or obvious answer. This is, if the former president of the United States is to be indicted, it will be the first time that has ever happened in the United States' history. And though that does happen with some frequency in other nations, we tend to think that many of those are banana republics. We tend to think that it's a sign of the diminution of their political success, not a good thing. There are exceptions to that. Of course, Israel has a vibrant democracy and has on several occasions brought criminal cases against its former prime ministers. But this is a big step. I would break down my thinking about this in a few pieces. The first is there enough evidence to bring the case? And Norm is right that the case against the president with respect to January 6th has gotten better, much better, with the work of the January 6th committee. The evidence that they've adduced is quite interesting. The reality, though, however, is at least twofold, which is, first, not a lot of it directly ties to President Trump himself. Much of it is about what happened on the ground January 6th. Much of it is about things that he did that might otherwise be legal, like thinking about firing the attorney general. He had a bad motive, but he's entitled to fire the attorney general. And some of the most powerful evidence is tied to his failure to act. That is, his failure to stop the violence once he realized it was going on. And every prosecutor worth his salt knows that failure to act cases are a lot harder to prove than acting cases. If I kill you, that's one thing. If I don't stop Norm from killing you, that's a different thing altogether. And it makes it a much harder case. But for purposes of this discussion, I'm willing to begin with the assumption that there's sufficient evidence at least to indict, and almost certainly to convict. But that's in an idealized world. In an idealized world, notwithstanding our belief in the presumption of innocence, the prosecutor typically starts with a really significant advantage. Most jurors think that they wouldn't be there if there wasn't some reason for the government to think that somebody had done something wrong. That's not going to be the case with President Trump. So my first concern is that the government won't win. Now, that doesn't mean they shouldn't do it, because as Norm says, that might very well they might do it for other reasons involving affirming the rule of law. But I'm reasonably confident that it will be difficult to get a unanimous jury to convict Trump. Not necessarily because there's a lack of evidence, but as much because jurors have a history of nullifying prosecutions that they don't approve of. And if anybody is going to be thought worthy of that kind of unthinking loyalty, it's likely to be President Trump. And so I'm concerned in the first instance with, if you come for the king, you have to kill him. And if you don't, he will get a reputation as the Teflon president and be more empowered rather than less. So I worry about that. Even if they do convict, I worry greatly about the appeals process, both because there's bad appeals law about the obligations of politicians that the Supreme Court has been building for 20 years, but also because my own sense is that any Republican president who were elected in 2025, if that were to happen, would pardon President Trump. And that surely Trump would pardon himself. But I think even a President DeSantis or a President Tim Scott would do that. And that makes a lot of this effort a challenge. And then my final point, all of which is not to say that I'm convinced 100% that I'm right, but why I have such great hesitancy is that to a large degree, America is founded on an idea of civil peace, the peaceful transition of power. And that has been eroding to a very real degree in the last few years. The January 6th riots being the most notable example of that. I have a reasonable view that the indictment of Donald Trump will be like throwing oil on a fire. That may not be a reason to not bring a prosecution. You cannot let the insurrectionists have an insurrectionist veto over the law. But it's a very real concern. And it's very, very difficult to find a way forward that is likely to be successful. I mean, the only way that I can really see it is Garland brings an indictment. There is not a civil unrest of any great amount. They get a conviction and the Democrat wins so that Trump doesn't get pardoned and go to jail. And that's a lot of ifs for a successful prosecution from the perspective of American society. And so I worry about how we will go with that. I think for myself that the best answer to Trumpism is to reject it at the ballot box. But that's not why we're here. There you go.
Thank you. That was equally vigorous and concise. Let me turn back quickly to Norm because you raised a couple of issues I'd like him to tackle head on, but briefly. One, could you find a jury to convict? And it's in the canon of what I'm not a lawyer. You guys are. That's why you're here. But that the Justice Department should not bring charges that it doesn't think it can secure conviction on, number one. Number two, should the Attorney General take the potential consequences of an acquittal or even a reversal on appeals into consideration when he makes this decision? And finally, that very interesting problem of the civic consequences, throwing gasoline on a fire. Is that something the Attorney General should be bearing in mind? Norm?
Thanks, Doyle. Thanks, Paul, for your trenchant analysis. Starting with the jury question, and Paul and I have both made a good living by talking to juries over the years. And I've served on juries, including on one occasion as the foreperson of a jury. So I'm one who has great faith in the American jury system. I think it brings there's a perpetual argument about whether jurors can bring the right dispassion and expertise, or whether we really should have judges deciding our important cases. But in one form and another, 35 years of dealing with juries has led me to believe that yes, particularly a jury, I believe this prosecution would be brought in the District of Columbia. And so federal jury in the District of Columbia, I have confidence that even if there should be some Trump voters on the jury, probably would not be right if there were not any. And I think some would make their way through. Perhaps not as many in the District of Columbia. And that's something that prosecutors will privately look at. Not as many as if we were trying the case elsewhere. We're not, we'll talk about the Fulton County state case, perhaps. Maybe we'll touch on the Mar-a-Lago case, which could be in DC or in Florida. Those offer different jury pools. So yes, I return to the fact, and Paul has moved since Paul was at your article in The Atlantic, where you were more cautious before the January 6th committee had really unearthed the evidence. Doyle, and I've got to accelerate here because this is just in the nature of my reply or rebuttal argument. What we've seen goes beyond where we started with the failure to act. And now I think we have seen a set of affirmative acts of testimony that Trump called around the country on those likely crimes to the likes of Romney, McDaniel. Hey, can you help me get he didn't call him that, but the fake electoral slates. We've heard the tape of his call and the testimony from Brad Raffensperger, the Secretary of State in Georgia, pushing him. Phony 11,780 votes, find 11,700 that don't exist. So we've seen much, and Trump's actions on January 6th, and we're going to get more of this tomorrow, they are not a failure to act, they're affirmative acts. We now know from Cassidy Hutchison, Trump knew that the mob was armed. He said, take down the magnetometers. He wanted to march with that armed mob. We'll get corroboration tomorrow. He was enraged when he couldn't do it. And then he went back to the White House and he chose not to act and then targeted Mike Pence, knowing the mob was coming after Mike Pence with a highly inflammatory tweet, which was read on a bullhorn. Those are affirmative actions. You can't incite a crowd, including with his remarks, set fire to the building, then, take further affirmative actions. That's a very powerful case to a jury, especially in the District of Columbia. I think it can survive on appeal. I base that on the fate of Trump's bogus litigation, for example, in those 64 cases that he lost. The so-called Trump judges, I think he'll continue his pattern of losing, particularly in the DC Circuit at the Supreme Court. So acquittal is always possible. I think the consequences could include unrest, but this is where I want to stop, and it's appropriate for the LA World Affairs Council, because as an ex-ambassador, as a Brookings scholar, although I'm speaking today in my personal capacity only, I don't only study these issues in the United States, but globally. And I think the lessons of history, the lessons of dealing with contemporary backsliding are that the consequences of failing to act against a movement, and election denial is now a movement. This is not an isolated episode. It's running like wildfire. I just published a Brookings analysis, 317 election deniers running all over the country, including, I think, 15 in California. That movement poses more danger. This is where I started. More danger if we don't act. That's the lesson of history. So that's my answer.
Paul, I'll let you, if you want, rebut anything particular Norm just said. Has he convinced you, for example, that your fear that most of these charges are for a failure to act is no longer a valid objection? But I'd also like you to turn to the distinct questions of the Mar-a-Lago investigation. Do the circumstances of Mar-a-Lago, which on the face appear to be a clearer, simpler, and potentially quite damning set of circumstances, does that change everything in this picture?
It certainly makes for an easier case to prove, I think. I think Norm would agree. I agree with Norm that the case has gotten stronger. I think Norm would probably agree that the January 6th case is much more complex than the Mar-a-Lago case. It involves literally 6 or 7 different strands of activity. Mar-a-Lago's easy in terms of understanding and explaining it to a jury. That having been said, from my own perspective, if I were counseling Merrick Garland and he were obliged to choose, I would not choose that case. Part of it is the practical reality that a jury pool in Florida is different from a jury pool elsewhere. And probably the first fight in a Mar-a-Lago case would be whether or not the trial should be in Mar-a-Lago in front of somebody like Judge Eileen Cannon or in DC. And that would be a 6-month thing. But I think the more salient point really is that it smacks of and it will smack to the public, especially the Trump-loving public, as getting him on a technicality. Al Capone and the tax fraud. The reason that we're talking about indicting the former president of the United States is not because he took the classified documents with him to Mar-a-Lago. I mean, or if you imagine a counter hypothetical world in which that were the only thing he'd done and January 6th hadn't happened, we'd be yelling at him, we'd be wanting to get the documents back, but I submit that there's no way in the world Merrick Garland would consider that for indictment, any more than we really wanted to indict Bill Clinton, even though he, as he admitted in the end, had lied under oath. We just would rather buy social peace than go through that. So with that in mind, if Attorney General Garland were to ask my advice, which he has not, I would say, if you think that this is worth doing, it's worth doing for the reason that January 6th is too important. It's transformative. You can't let that pass away. And take your risk. If you think it's that critical, take the risk of the hung jury, and put on your best case and hopefully win it. But I don't believe that, from my perspective, it would be a wise application of federal discretion to make the Mar-a-Lago case. Now, you could make the Mar-a-Lago and January 6th. I leave that to others, but I would not do January 6th alone. I mean, Mar-a-Lago alone, because that's kind of like, you can hear his supporters now. That's all that they got on him is a technicality, and he declassified the documents anyway. You can hear it already in your head. So I wouldn't go in that direction.
Norm, Mr. Trump does face one other serious bit of legal jeopardy that you have referred to, and that is the investigation of the district attorney in Fulton County, Georgia. So please bring us up to date on that one.
Well, one of the other, of course, we're trying to live inside, and Paul knows him. I've known him for over 30 years, since we were young lawyers starting out. We're trying to live inside Merrick Garland's prosecutorial imagination for purposes of this seminar, these remarks, this panel. But there's another prosecutor who I think is very important, perhaps more important to accountability for January 6th, and that's the Georgia DA, Fulton County, Atlanta DA, Fani Willis. She was much quicker out of the box than Merrick Garland. She had a more discrete set of tasks, which was President Trump's assault on the election in Georgia. She had the advantage of this really shocking tape recording. Just, quote, find 11,780 votes. To Paul's point about the complexity of the national case, she had a simpler Georgia-based case. He called somebody and asked for phony votes. He was involved in suborning Georgia phony electoral slate. He sent Rudy Giuliani and John Eastman, his coup lawyers, to Georgia to press lies in Georgia. And then his inside coup lawyer, Jeffrey Clark at DOJ, was trying to get DOJ to write a letter to Georgia, opening up to upset the. So she had a more discreet case, and she's a very intrepid prosecutor. Doyle, Paul, her most famous case is taking on an even more politically tricky group of defendants, the Atlanta teachers in the famous Atlanta teacher cheating scandal. She was trying our kids' teachers for cheating, so the kids could perform better. I mean, that was not a popular, most people give the teacher not a subpoena, not an indictment. So, and she won that case. The facts are a good fit in Georgia. The law is a good fit. she tried the teacher case as a RICO case. Georgia RICO is much more expansive than the federal version. It encompasses these allegations, and there's a very nicely fitting solicitation of election fraud that goes with the phony electoral slates and the false statements to the Georgia legislature, and just fined 11,780 votes. So and one of the attractive things about the Fani Willis case, and I'll stop here, is that some of the political considerations that Paul points out, I think they ultimately cut the other way, but she was not appointed by the winning presidential candidate who defeated Trump. She's off in Atlanta. She was appointed by the voters of Atlanta. So there's a level of political insulation from this, the winner persecutes the loser tradition in some.
Norm, you're beginning to break up on our screen, so I think I may stipulate that you've just brought your point to a very eloquent conclusion, because something tells me that our audience is probably bursting with several questions. And Norm, you're still frozen on my screen. Paul is
Mine as well. I think Norm is gone.
Can you hear me?
We can hear you, but we can't see you move.
I'm gonna come in as an experienced LA boy. I've got a backup device, backup iPhone. I'm gonna exit here and I'll come right back in on my iPhone.
And that is a perfect moment for us to turn to Rachel Kenderdine, who has been collecting questions from the audience. And so, Rachel, please get us out of this mess.
Yes, hi. Thank you all so much for joining us. And thank you, Ambassador Eisen, for having the backup device ready to go. I see you're already back, so that's great. Yeah, so we have a ton of questions coming in from our audience. So I want to get to as many as possible. So I'll start with this one, which I will direct it to Paul first, and then whoever wants to jump in, please feel free. So Paul, one of our audience members asks, would conviction on a state charge prohibit Trump from running for president in 2024? If so, what type of state convictions would prevent a run?
The answer to that is pretty clear, though of course we've never tested it, but neither a conviction on a state charge nor a conviction on even a federal charge would by itself prevent President Trump from running. Canonically, he could have been prevented had he been impeached, convicted, removed, and disqualified. We know that didn't happen. There is an abstruse lawyers' debate about whether or not Congress can set further conditions on a person's ability to run for president above and beyond the very few that are in the Constitution itself. You have to be over 35. You have to be born in America. Most people, we've never resolved that. So if we had to say, for example, that you had to show your taxes in order to run, if Congress passed that law, most people tend to think that that might not be okay. But whether it's okay or not, Congress has never passed a law saying that only people who have not been convicted of felonies can run for the presidency. And in the absence of such a law, the question of whether or not it would be effective is kind of, lawyers dancing on the head of the pin question. So the bottom line answer, to repeat, is Trump can be convicted. He could probably even run from jail. And if he was since it's a state prosecution, since he couldn't pardon himself of a state offense, he might have to actually, issue his orders from the little Oval Office in the Atlanta Fulton County Prison. In theory, he could. That's the rule. I don't think it's a sensible rule, but I think that's the rule.
I'll just add briefly, mostly just because I'm enjoying having a backup device to talk on. I'll just add briefly that the corollary to this is that if he's convicted of a crime, he can run. But if he's found to be an insurrectionist or to have given aid and comfort to insurrectionists under the 14th Amendment, Section 3, he can't run. And lest you think that is fanciful, Crew, which Paul knows well, and which I co-founded, has just secured a victory in New Mexico federal court for an insurrectionist who had office in New Mexico, and a federal court has barred him. He ended up being charged for the charged and convicted for his activities on January 6th. Relatively, he was not in the most serious category of offenders, but nevertheless, simply for setting foot within a place where he wasn't supposed to be, he's barred federally. And pay attention, folks. It hasn't gotten a lot of attention, but one of the big coming things is you're going to see around the country, including in California, people who are going to say, wait a minute, when we get this final report of the committee after the election, does this provide a sufficient basis under the 14th Amendment, Section 3? It's important the committee speak to that. And I'll be writing much more about this in the weeks and months ahead.
Well, I have another question that I'll direct to you first, Ambassador Eisen. One of our audience members asked, if we don't prosecute, how do we prevent future presidents from committing similar wrongdoings as Trump? And why can't we prevent him from running again, which we just got a little bit into. So again, if you want to start and then whoever wants to jump in, please feel free.
Well, I do think that that is the ultimate calculus, and the walls are closing in between the two federal grand juries, at least two that we know about, focusing on the fraud against the United States, 18 U.S.C. 371, the obstruction of an official proceeding in Congress when the fraud didn't quite work, 18 U.S.C. 1512, the violations, apparent violations under the Espionage Act, theft of government documents, and a different obstruction statute, 18 U.S.C. 1519, in the Mar-a-Lago documents, Fani Willis's Georgia investigation. Those are four walls closing in on Donald Trump. And even if he can technically run, it's not going to be so easy. That's why those who are anxious about the future of totalitarianism in the United States should cast an eye not just on Trump, but on Ron DeSantis, the heir apparent to this movement, who, by the way, is traveling. He's just as contemptuous as Donald Trump for the rule of law. I have an article in CNN Opinion laying out his many violations. I think he's committed possible crimes. I've written about that for Just Security with the migrants to Mar-a-Lago stunt. He's really he may be an even more dangerous version of Trump, and he's traveling the country supporting election deniers. So, as Trump goes down, which I think he will, often when you study around the world, others rise. So it's beyond, maybe we'll do another one on the heirs of Trump. I wrote a book about him called Overcoming Trumpery. I'm as worried about Trump, but I'm also worried about the other advocates of Trumpery. That was my last book.
I'm going to take an answer to that question, Rachel and Doyle, in a slightly different direction, which is to say that if the question is, how do we prevent presidents from abusing their power in the future, right? The prosecution of an abusive president is one answer, and if we're successful, that will deter the next bad actor from acting. But there are at least a couple of other really important answers that are worth talking about that don't involve Trump. The first is that we can strengthen the laws against executive discretion and executive unreasoned executive action. Most of our laws these days, everybody would agree, we have a very strong executive, has a huge amount of discretion to do almost anything that he wants if he calls it a national emergency. There was a book published right after Trump left by Bob Bauer and Jack Goldsmith. Jack is at Harvard, and Bob is a longtime, well-known Democratic lawyer, with a list of, I want to say, 24 reforms on how to, cabin the ability of presidents to, fire inspectors general without cause, to people their administration with appointees who have never been confirmed by the Senate. Whole host of things. It is, in my respectful judgment, shameful that the Congress has not seen fit to take up any of these, except for the proposed revisions to the Electoral Count Act, which look like they may be coming through Congress. That is not a Trump-specific reform, and that's probably why they didn't do it, because it's not as sexy, but it really is essential for those who want to reinvigorate legislative power and restrictions on the executive branch, so that if Ron DeSantis or anybody else who has an authoritarian bent were to be elected, they would be much more restrained. But that leads me to the second point, which is really, I think the fundamental point, and which is it's on us, right? I think it was Oliver Wendell Holmes said that, if men were angels, no law would be necessary. If they're devils, no law is sufficient. We have to elect people who are reasonable and act within the bounds of, there's a huge difference between whether or not you like Barack Obama or George Bush and their policies and Trump. Bush, Obama, Reagan, all kind of within the bounds of reasonable expectations. Trump, different. DeSantis, quite possibly likely to be different. So it's on the electorate, because all the laws in the world can't prevent abuses of power in the long run. It's an ultimate degradation. So yes, deter the future people by going after Trump, but pass stronger laws to limit what he could do if he were reelected, and then don't reelect him. or don't reelect DeSantis if you think he's an authoritarian. Don't reelect Bernie Sanders if you think he's an authoritarian. Just don't elect bad people. It's pretty easy. It's not really that easy, but pretty easy solution. Not an easy result.
Easier said than done. Rachel?
Yes, easier said than done.
Yes, thank you. Thank you for those perspectives, both of you. So Doyle, I'll direct this next question to you first. We have a string of questions coming in about Trump's potential charges and his different cases that are currently in play. So the first question about that was from an audience member who asked, the Mueller report included multiple incidents of obstruction of justice that former prosecutors indicated were indictable. What happened to those potential charges now that Trump is out of office?
They sit there in the Mueller report with not being acted upon. I'm making a political judgment here, not a legal judgment. It seems to me quite unlikely that the Attorney General would want to go back to the Mueller report and open that particular enormous Pandora's box to resurrect those charges when one of his problems, as we've seen in the last half hour or so, is that he has a lot of other new evidence on his plate and a lot of other judgments to make. So I don't expect those potential obstruction charges to come alive again. I'm always happy to be put right, though, by our distinguished lawyers.
For many of them, the statute of limitations has run. It's a 5-year term, and so that's October of 2017, and a number of the things that Trump was alleged to have done happened beforehand. Attorney General Garland would have had to have acted very, very quickly to bring those before the timeframes ran out.
Thank you, Counselor.
I would make the argument that there still are some available statutes of limitations. I don't think they've all run, but it doesn't matter,
Right.
because he's not bringing it. I mean, those are for purposes of and that's a different set of political judgments that the Attorney General made. He's treating the prior Attorney General's determinations and his staffs and the criminal divisions as settled law, the law of the case, if you will, and he's not reopening that. That is part of the judgment that was made to restore credibility to the Justice Department and to build up the political capital, whether you agree with it or disagree with it, to build up the political capital that now will make these decisions on the January 6th crimes, Mar-a-Lago, possible because that capital has been built up again. So they're dead. I think, sadly, people have different views.
But that's, Norm, you make a great point that we haven't touched on, and that is that if we are trying to divine Attorney General Garland's decision-making process, one of the consistent threads in his career is the integrity of the Justice Department and the preservation of its precedents. And that set of judgments are paradoxically perhaps going to pull him in both directions on these questions. So Rachel, next question.
And before we do that, Royal, am I allowed to tout a competitor of yours?
Oh, please do.
Right. Well, I highly recommend for everybody. Franklin Foer recently wrote a profile of Merrick Garland in the Atlantic. It's 4,000 words. It's a beautiful piece, well written, well researched. And his conclusion, for whatever it's worth, is that precisely because of his commitment to the rule of law, in the end, Merrick Garland will follow Norm's advice and bring charges. And he'll follow mine and bring them on the January 6th case. Franklin can explain to you why he reaches that conclusion. You should read it yourself. But it really is a beautiful piece. And if you're interested in this question and thinking of it from a realistic, practical terms, I highly commend it to everybody.
And it's in the Atlantic, and you'll find it. This is an admission against interest. You'll find it at theatlantic.com.
Yeah.
As somebody who's read the LA Times all my life that I can remember, as a daily newspaper, I do not admit the Atlantic as a competitor to the LA Times. Other than that, I agree with my colleagues. I'm really loyal to the Times and the Dodgers and the other Los Angeles institutions of my that I grew up with.
I should have mentioned earlier, one of our questioners said "Go Dodgers" in their comments. So
only one. We have 258 participants.
So the next question, we actually have two related questions. We had several come in about the jurisdiction of Trump's legal troubles. So I wanted to direct this to you, Paul, first, because I know that you've written about it. But they asked, they said, since the theft of the archived documents happened in DC and Florida is where they were stored, wouldn't DC have jurisdiction for both matters? Can a conservative and or Republican get a fair trial in the Washington, DC metro area?
Well, taking the first of those questions, about jurisdiction over the theft, I read recently an extensive analysis by a classified a lawyer who practices in classified information, and his conclusion that I have no reason to doubt is that it's arguable that DC might be improper because at the time he removed them, he was still president, possibly, right? Depends upon a fact we don't know. And so, the failure to return is an act that he's doing in Florida. I would think that before they brought the Mar-a-Lago classified documents charges, the Department of Justice would make sure that it had an answer to that question that it thought it would win on. And the simple fact that we keep calling it the Mar-a-Lago case kind of makes me, without doing the legal analysis, but makes me at least concerned about venue. As to the second question of fairness in the jury veneer in DC, yes and no. I mean, the same is true almost everywhere. Can a black man accused of killing a white woman get a fair trial in Alabama in front of a white jury? We believe strongly in the validity of using geographic location for the creation of jury pools. It's been that way for 227, 32 years, however long since the Constitution was passed. And there's no realistic prospect of changing it. I think that what you've heard in our discussion here is a very candid and realistic assessment of the fact that, DC voted 85% for the Democratic candidate. Georgia was 50-50 and Florida went for Trump. And that's reality. And so long as we have a federated system where jury trials happen in the place of the crime, we can't change that. What we can do is do our very best to weed out from the jury people who are biased from the start. And as Norm said, both of us have appeared in front of juries. I've often asked questions that were designed to elicit people's true views about something and whether or not they were coming with an open mind. And I'll be honest with you, I have succeeded, but I have also failed. And I have indeed had hung juries and lost cases, hung juries for sure, because of what I perceived to be jurors who were unwilling to put aside their pre-existing prejudices. Unless we're going to go to judge-made decision-making, that's a feature, not a bug. And I like Norm, I sure wouldn't want to go in that direction. Aristotle said that if he had the choice of giving up the vote or giving up the right to sit on juries, he'd give up the right to vote first. And I think he was correct.
To agree with Paul's point, you show me a trial lawyer who's never been tripped up by a failure in voir dire, a failure in jury selection. And I'll show you somebody who's never tried a case, because if you try a lot of cases, every crazy thing that can happen will. It's really always a question of the law of averages. Some folks are better than others, and Paul's one of them at beating the averages. But, a lot of strange things happen. So there's no guarantees in any of this. And even Frank Four points out that he's making a prediction based on currently available facts. It's not a guarantee. And nobody can guarantee how any of this is going to turn out. And certainly there's no guarantees, but I think you can get a jury that will convict. And there's arguments about jurisdiction. It will be, DOJ will have a reasonable shot at keeping the case in DC if they bring it in DC, but no guarantees.
Great. Well, I think we have time for one final question. We've had a number of questions come in from the audience about the case in New York State. So this audience member asked, Trump still has troubles in New York State, both civil and criminal. Do either of those cases play a role in the current environment? And whoever wants to jump in, feel free.
Well, the civil case certainly does. He's been sued, and the Attorney General is seeking essentially to take away his companies or take away his right to participate in his companies. I'm no Trump whisperer, but I actually sort of think that that might hurt him a lot more than the criminal charges in some ways. The criminal charges themselves, the original set of them were declined by the Manhattan District Attorney, Mr. Bragg. The New York Attorney General has said that she has uncovered more evidence and is re-referring them to Mr. Bragg and also to the federal officials in the Southern District of New York. You know, it's way too early, I think, to say whether or not that will have any legs. I suspect that Mr. Bragg will not reopen the case simply for the same. He's already made his decision. Whether the Southern District of New York chooses to do so will a large degree depend upon what Merrick Garland tells them to do. And so we're back to the same question we had before, which is, what does the Attorney General think is the best way forward?
You know, the word on the street among the New York, there's this saying, in the halls of justice, justice is in the halls. And the word on the street among the New York practitioners is that Bragg was burned. I've been a severe critic of Mr. Bragg's failure to bring charges when he had proof beyond a reasonable doubt on non-political, Rachel, those were non-political. So these issues that we've talked about, this was financial crimes by a non-federal prosecutor. Indeed, two of our most distinguished, I don't know if you know them, Paul, but they're good friends of mine, Kerry Dunn and Mark Pomerantz, two of our most distinguished prosecutors quit the case because it was such an outrage. So word on the street is Bragg fell in the halls of the courts in New York. Bragg feels burned, and he's trying to bring something back if he can. We'll see if that happens. I'm dubious about it myself, but the civil case in New York brought by the New York Attorney General, Tish James, is not to be ignored, and I think was implicated by the question, because while it won't put Trump behind bars, it hits at his financial base, his family, his dignitary base. It's kind of a corporate death penalty case. Says the Trump enterprises named in that complaint are so corrupt, so fraud-ridden that their ability to do business in New York must be removed. The certificates that they need, that a monitor has to replace Trump on the throne. Trump can't be an officer in New York corporations. He can't do real estate deals. He can't take out loans. It's a very devastating, if she wins, a very devastating blow. That is another consideration to be taken account of.
Well, thank you all so much again for being here today, and for answering some of our audience's questions. And thank you to our audience members as well for sending in the questions. We had some really great ones, so just always appreciate you. So I will turn it back over to you, Doyle, and thank you again.
Well, thank you, Rachel, and thank you for handling the questions. We are right up against our time limit, but I'm going to test it by asking each of you to take just 30 seconds more to hazard. Unfair to ask you for a prediction or a forecast. Your best guess let's say by the end of next year, do you expect, more likely than not, that Mr. Trump will be facing a federal indictment? Paul?
Believe that the power of the evidence that Norm has adduced is too great for the Attorney General to fail to prosecute. Notwithstanding my own caution about that, I believe he will bring an indictment in the early part of next year and on the January 6th matters, and I worry greatly about what that will do to our country. But I have fond hopes that it'll turn out better than my pessimism suggests.
Nora?
Trump will be indicted on federal and state charges. I believe the state charges, this is my present guess based on the evidence, my best guess. I believe the state charges will be brought by Fonnie Willis before the end of 2022, with federal charges on the Mar-a-Lago case to be brought in the first quarter of 2023. And I think that there will be a hard, I disagree with Paul. I think they may do the Mar-a-Lago as a standalone. They're showing no great signs of alacrity on the other two federal cases with unenforced subpoenas and whatnot. So I do think we'll see those two.
Thank you both. Thank you both for all your time here. This has been terrific. Thank you. I'm glad, since we have one veteran of a Republican administration and another veteran of a Democratic administration, that we had some vigorous points of disagreement as well as agreement. And I want to thank all of the members of the World Affairs Council and Town Hall for helping this happen, and especially Kim. Kim, it's all yours.
Gentlemen, Doyle, Paul, this was so informative and very fascinating and interesting on so many levels. I would love to bring you all back and continue this conversation when we're a little further down the road on all of this, maybe next spring. But thank you so very much for your time.